Welcome back to Class Act, Updates in Education Law. I'm Miriam.
I'm Christina, not Lisa.
Lisa is not here today, so we are joined by Christina Pierre, also an attorney at Walter Haverfield, and we get together every so often. We talk about the latest legal developments affecting school boards, administrators, teachers, anybody who works with kids in the schools. Today, we are going to be talking about manifestation determination reviews and common mistakes that we see special education teams making in these MDR meetings. If you are a longtime listener of this podcast, you know that we have previously talked about MDRs, and I think it was the first season all the way back, season 1, episode 15, as part of our series on discipline. So if you want a more comprehensive analysis of MDRs, and you'd like to listen to our episodes, our series on discipline, you can do that. And also I wanted to say that all of our podcasts, aside from being available on Stitcher or iTunes, wherever you get your podcasts, all of them are also available going all the way back to our first episode. They're all available on our website, walterhav.com/podcasts. So you can go there and listen, or you can try to find it wherever you get your podcasts on whatever app you use. In any case, so let's talk about MDRs, but first, give us a little background, Christina.
Okay, so an MDR, a manifestation determination review, right? So what is it and why is it important? So a manifestation determination review is where a child's IEP team gets together and they determine whether or not misconduct that a student engaged in that violated the student code of conduct, so it can be anything from skipping class to fighting to bringing drugs to school, any activity that they've engaged in that violates the student code of conduct, their IEP team gets together for a manifestation determination review to decide whether or not that conduct was caused by or substantially related to their disability, right? So a manifestation determination review is not a hearing. It's not a time for a parent to challenge whether their child engaged in the misconduct or not. In fact, for a manifestation determination, we actually assume that the misconduct took place,
and
right?
That's an important point, yeah.
Because if we don't assume that the misconduct took place, then we can't decide whether or not it was related to the student's disability or not. So sometimes parents get that a little bit confused, and sometimes school districts add to the confusion because they tend to call them hearings, right? We had to do a manifestation hearing for the student.
Right, it's not a hearing.
But it's not a hearing. It really is an IEP meeting with a very specific purpose, and that specific purpose is to determine whether or not the misconduct was caused by or substantially related to the student's disability. Why is that important?
Yeah, why is that important?
So that's important for a couple of reasons. First of all, if conduct was related to a student's disability, right? So if a student's disability caused them to engage in whatever the misconduct was, then we cannot discipline them for that misconduct in the same way we would a non-disabled peer, because that would be discriminating against them on the basis of their disability, right? So I wouldn't punish a student for being in a wheelchair any more than I would punish a student for engaging in some other conduct, like maybe they were very mouthy with the teacher, but because of their disability, that's part of their disability. It's part of an issue that we're trying to address with them.
Right.
So same type of thing. So that's one of the reasons why manifestation determinations are so important. It's also important because students with disabilities are entitled to certain protections before we would change a student's placement, right? So a lot of times, if we're looking at a manifestation determination, we're looking at a pretty significant disciplinary infraction that's going to result in the student being out of school for a good period of time. So any days of removal over 10
that's important.
within one school year, right? So if you have a student who consecutively or cumulatively is going to be out of school for more than 10 days in a school year due to discipline, that's when they're entitled to this manifestation determination. If it's a really significant code of conduct violation, so let's say it's a student who was in a fight and somebody was injured in the fight, so not a little fight, not just a little bit pushing and shoving, but a really significant fight, sometimes they might be up for a 10-day suspension with maybe a recommendation for expulsion that's going to remove them from school for much longer. Because we're removing them from their educational placement, we have to decide before they can have that removal whether or not their behavior was caused by their disability or substantially related to their disability. So that's kind of manifestation determinations in a nutshell.
Right, and I think what you said is I just wanted to emphasize that it's 10 days. So a child's placement, a child's educational placement is not considered changed until the child has been out for 10 days. So if you're in a situation where the student has cumulatively has already accumulated 5 days over the course of the year, and now you are adding on another 9 days for the next infraction, that child's 10 days will come in the middle of that 9 days, and you're going to have to hold an MDR to decide whether the additional days can be implemented or whether the child needs to go back to their regular classroom. And I think, I just want to note that if the team decides that the behavior leading to the discipline was a manifestation, the student is generally returned to class.
Correct.
And the suspension or expulsion is cut short. Sometimes we have situations where a student has already missed more than 10 days, and in those cases, typically the team will offer compensatory education to that child.
Right, for any days that they miss over the 10, up until the point where we can get the manifestation determination review scheduled, because under IDEA you have 10 school days to schedule that manifestation determination review. So it doesn't have to be scheduled on exactly the same day that the student engaged in the misconduct or when the disciplinary infraction occurred. You do have some time in there, because again, this is an IEP meeting with, again, a very specific purpose. So you're going to want to make sure that you got the entire IEP team plus the student's parent, participating in this process.
And another thing I didn't mention is that if the behavior is a manifestation of disability, the team has to take a look at the FBA and BIP for that student. And if you are confused about what those acronyms mean, we just talked about them. We literally just talked about them 2 episodes ago. Is season 3, episode 11. So you can go back to that and listen to a full podcast episode about functional behavior assessments and behavior intervention plans. And I urge you to do that if you are confused about those topics. Another clarification I just want to make very briefly before we start talking about common mistakes that we see is about behavior that's a little bit more serious. So if a behavior involves weapons, drugs, or serious bodily injury, then even if the team finds that the behavior was a manifestation, that child is still allowed to be removed from their educational setting.
For up to 45 school days. So it's a shorter period than maybe what they would have been removed for under your student code of conduct.
Right.
But the idea is to give the district time to figure out, what are we going to do in this situation? So Congress understood that there were some offenses that were so egregious that even if they related to the student's disability, the student still needed to be removed from school for some period of time. Usually within that 45 school days, the team is going to be talking about, where's the student go from here, right? Because probably coming back into that setting that they were just removed from is not going to be the right answer for them. Where else could they go to get their education? Something else that we didn't mention that we want to make sure we clarify. For students with disabilities who are identified under IDEA, we want to make sure that you understand that for those students, if they are removed from school, any days in excess of 10 during the course of a school year, that student is going to be eligible to receive services during those removals. So Miriam mentioned compensatory education earlier, so maybe you have a student who has been removed for 12 days or 13 days, something like that. They're going to be entitled to services for any days over 10 that they've been out. For a student who might be facing a longer term removal, so take my example from earlier, like the student who's in a really significant fight, let's fast forward our regular education discipline and let's say that they were suspended for 10 days, they were expelled for 80 days. During the term of that removal, they're going to need to receive educational services in what's called an interim alternative educational setting, which is just another setting for them to receive services in. The really important point here is that that setting has to be determined by the student's IEP team. Sometimes like a building administrator or the district superintendent or some other administrator wants
Right.
to make that decision, but that's a decision for the IEP team, and it has to be a setting where they're going to be able to make progress on their IEP goals
Right.
and also make progress within the general curriculum. So that's something that's very unique in special education law under IDEA, that these are kids who have technically been expelled from school, but the school
Right.
is still going to have to provide them with educational services during that removal.
Right, and I think this applies also if the behavior was not a manifestation of the child's disability. So if the behavior is
Correct.
not a manifestation, you are permitted as an administrator to discipline that student as any other non-disabled child in your district is disciplined for that behavior. But if the child is removed from school, you still have to provide IEP services. So essentially, once a child has an IEP, they're going to be receiving IEP services.
Correct.
Regardless of where they are over the 10 days.
That's
Yeah.
exactly right.
So I think now is a good time to talk about some of the common mistakes that we see. And these are mistakes that we see in our capacity as attorneys because we often get called in after a parent complains. Oh, you know, my child was expelled or suspended and the team didn't follow the rules, and then there's a administrative hearing about this. Or sometimes we hear about this from administrators who call and say, you know what, I don't know if we did the right thing. Can you help us out and guide us? So here are some of the more common mistakes that we see.
So one of the ones that we see most frequently is when the team fails to take into consideration all of the information that's available about a student. So maybe they get too focused and too hung up on, well, what's that student's eligibility category under IDEA? Because, for example, again, we'll take my fight example. So a student with a specific learning disability, who's identified as a student with a specific learning disability, couldn't possibly have engaged in this fight as part of their disability. And what they might have overlooked is a lot of other information about the student
Right.
that says, well, this is a student who has a specific learning disability, but they also have maybe some mental health issues, or they have some emotional disturbance issues, or they have some ADHD issues. These are all other things that could have
Right.
impacted the situation. And if you don't consider all of that information, then you've only considered, a small sliver of what's out there.
Right. So for example, if your team says, we are only looking at the evaluation, which happened 2 years ago, and the mom says, look, I have a diagnosis from this doctor last week that my child has bipolar disorder, and the team says, you know what, that's not important. We are here only to talk about
Right.
that evaluation. And your son just has a math disability according to that evaluation, so this is not a that would be wrong.
Right.
That would probably be a violation, so don't do that.
Yeah, no,
Yeah.
you've got to make sure that you're looking at everything, particularly things that the parent might bring in. And I understand it's hard sometimes for teams because you're like, oh my gosh, parent, how long have you had this information that you didn't share with me, right?
Right.
So in the example Miriam just gave, it was a new diagnosis, but I've also had situations where maybe the diagnosis is a year old,
Yeah.
and the parent just never shared it before. And now that we're in a situation where maybe it's important because it impacts, whether this is a manifestation of the student's disability or not, now
Right.
all of a sudden the parent is sharing.
Right. And I think one of the cases that we recently discussed from the Ninth Circuit emphasizes this point really well. The point that when a team is looking at everything, they need to look at everything, and they can't just rely on cherry picking what they would like to do to perhaps expel the child. And this is the case out of the Ninth Circuit, very recent case from last year, JF versus William Hart Union School District. This was a school district that the Ninth Circuit found was in violation because this was the case where the school psychologist said, yes, so this student has an emotional disability, and yes, they threatened other children, but it's okay. We can still expel him because typically emotional disturbance would manifest itself for this child in sadness or in inappropriate conduct, but not necessarily in threats. So this child was expelled based on the team's reliance on the school psychologist, and then the parent complained, filed lawsuits, moved up the chain until the Ninth Circuit took a look at everything and said, you know what, this school psychologist, although she was entitled to her opinion, perhaps the team should have looked more carefully at this child's extensive history of making threats. And because the team didn't look at everything, we're going to invalidate that MDR decision. You know, so that's, I think that court really emphasized what you're saying.
Mm-hmm. All right, so another situation that we run into sometimes is when a team will conduct a manifestation determination review for, say, fighting, right? We'll just take that offense and use it. So they conduct a manifestation determination review for fighting. They determine that it was not related to the student's disability. The student serves out their disciplinary removal, whether it's a suspension or an expulsion. They have services that they receive in an interim alternative educational setting during that time period. Mm-hmm. And then after that, maybe the student re-engages in that same behavior, right? So they're fighting mm-hmm. again. And I've gotten this call from school districts more than once. They'll say to me, well, you know, the last time Johnny was out, we did that manifestation determination for fighting, and we figured out that the fighting was not a manifestation of his disability, so do I have to do it again? Right?
Right.
So he fought again, right? Do I have to do it again? Like, what's the point? Do
Right.
I seriously have to go back and reconsider this for this new offense?
Right.
And the answer is yes, you seriously do.
Yes, you have to have another team meeting. You're going to have to meet again and talk about the same things again, even though you just did this. Okay, so another issue that we see come up is the interim alternative education setting. So as Christina, as you just mentioned, that is the place where the student will be receiving his or her services for 45 days.
Or longer.
Or longer. And this is a setting that needs to be decided by the team based on the child's individual needs. So the question for the team in deciding this IAES is, where can the child make progress on his or her IEP goals as well as in the general curriculum? And sometimes the school district does not understand that this is a team decision. So we've seen it both ways. We've seen it where an administrator just makes this decision. So the administrator will be like, oh, you know what, for these next 45 days, home instruction, your child's going to be at home, they're going to be expelled, we're going to send somebody out there for 1 hour a day just to make sure they're doing okay in school. And that's not appropriate because this is not a team decision, and very often that's just one administrator's decision, and very often the home instruction will not be appropriate for a student that may have IEP goals that cannot be serviced at home. At the same time, sometimes we see the other way.
Right.
So sometimes it's not the administrator making the decision or the team. Sometimes the team abdicates that responsibility to the parent out of the best intentions. Out of the best intentions.
All right. They're like, oh, parent, here are 3 or 4 different alternatives that we think would work for your child.
Would you like this school? Or would you like this school? Or would you like this school? We can place your child in any of these 3 schools. And the parent is angry at this point. The parent's
sure, their
not
child's being expelled. Yeah. They're not happy.
So there's, you know what? I'll think about it. I'll see. Next week I'll look at this school, and the next week I'll look at that school, and I'll let you know. And in the meantime, 3 weeks have gone by, and the child is nowhere. The child is not getting any educational services.
And guess who's at fault for that?
The
Here's
district.
a hint.
Yeah.
It's not the parents,
yeah,
right?
It's you.
This is on the district because it's the district's job and responsibility to make a decision about the interim alternative educational setting. And it's important to know that while we always want to be at a point where parents are in agreement with what we're doing,
Right.
at the end of the day, we don't have to have the parents' agreement to an interim alternative educational setting. So if we
Right.
can't get to that point, then we need to pick, we as a school district need to pick
Yeah.
an interim alternative educational setting that we believe is going to meet the students' needs, and then have good rationale behind that.
Right.
And then if the parent really wants to challenge it, then they can use the procedural safeguards that are afforded to them under IDEA. They can file a complaint, or they could file a request for due process to challenge the decision, which is never where you want to end up, but it's better to be in that situation than a situation where you literally have a student who's not receiving services because the
You're
parent is
waiting
kind
on
of
the
dragging
parents,
their
yeah.
feet, and you're waiting on the parent
Yeah.
to agree to something that they might not ever agree to. Another really important thing with that, and kind of a caveat to it, is after the team makes this decision, you have to document somewhere on the IEP the interim alternative educational setting that the team has decided on, and then also document it in your prior written notice that's going to go out after the meeting. So, again, it can't just be, well, verbally we talked about it and this is what we decided.
Right.
You've got to make sure that you get that in writing in those two places.
Yeah, that's very important. So, in other words, you do want the parents' input. You want the parents' input as a member of the IEP team, but the decision cannot be left to parents' discretion. You're not going to wait on that parent. You're going to make a team decision and implement that interim alternative education setting for that student.
Right.
Another common issue that we get is, and I guess this is a little bit less common, but we still see it, is sometimes school districts think this doesn't apply if the child does not yet have an IEP. So if a child is maybe in the process of being evaluated, the team will say, you know what, this is a non-IEP kid, so we don't need to worry about all of these laws and manifestation team meetings and all of that. There's no IEP here, so no worries. And that's also wrong, because these laws and these protections can apply to students for whom the process has already begun. And specifically, this can apply to students who are not yet identified under the IDEA if the school had knowledge that the child may have a disability. And the way a school is considered to have knowledge is if the parent expressed concerns about special education or related services in writing to an administrator or a teacher, or the parent requested an evaluation, or a teacher or other personnel expressed specific concerns about the child's pattern of behavior to a special education director or other supervisor. So if either of those three things take place, then the school may be considered as knowing that the child has a disability, and if that child engages in misconduct, violates the code of conduct, that child should be considered as entitled to all of those protections, including the manifestation determination review meeting.
So, and I want to break in and kind of put an important caveat on what Miriam just said, because everything Miriam said is correct. The issue, or the way that this would not apply,
Right.
is if you have a situation where none of those three things that Miriam talked about occurred before the student
Right.
engaged in the misconduct,
Yeah, that's
right?
important, yeah.
So the things that Miriam talked about, like the parent expressing concerns, or the parent requesting an evaluation, or school personnel expressing concerns about a pattern of behavior, all of those things, or any of those things, have to have happened before the student engaged in the misconduct that led to the disciplinary consequence. So in other words,
Right.
this is not a situation where you have a student where no one has ever thought about a disability, nothing's ever been suspected, the student gets in trouble, and then at the expulsion hearing before the superintendent, the parent comes
Right.
in with a
My
brand new
child-
diagnosis,
Yes,
or
right.
a brand new reason. Oh, look, here's my child's diagnosis of ADHD that
Now
I
you
ran
can't
out to
punish
get.
them,
Now
yeah.
you can't punish
Now
them,
you can't
right?
punish them,
Because
yeah.
that's not the way that goes. Now, that might lead to a situation where the team then says, okay, well, maybe now we suspect a disability, but that's not going to put the brakes on that punishment, So
Right.
the parent is not going to be able to literally stop discipline in its tracks,
Right.
by coming in after the misconduct has occurred and saying, but my child's disabled.
So what should a school district do, right? So if you do have that parent who came in and said, you know what, my child has this diagnosis, you can't punish them. So first you explain to the parent, like you said, that that the discipline process moves forward, but at the same time, you are going to evaluate that student in an expedited manner. So you are going to treat that request as a request for an evaluation. You're going to evaluate that child in an expedited manner, but in the meantime, while the evaluation is moving forward, that student remains in the setting where the district has decided. So, and if that's expulsion, that student can be expelled like any other child and treated like a non-disabled student, because the evaluation was not requested until after the misconduct took place. I hope that's clear.
I think that's clear.
Okay, good.
So the last one that we want to talk about, just very briefly, are students who are being disciplined for drug-related offenses, using drugs, and the parent comes in and says, well, this is a manifestation of my child's disability because they were using illegal drugs. Remember, we're talking about illegal drugs, right, to self-medicate, right? So I'm self-medicating my ADD, or I'm self-medicating my ADHD, or my depression, or whatever it is. And because of that, then this is a manifestation of my disability.
Yeah, that's very confusing.
Yeah, call me old-fashioned, but I have a really hard time getting on board with the idea of self-medication using illegal drugs that make something a manifestation of a student's disability.
Right.
I recognize that there are some states, certainly where marijuana, for example, is legal.
Right.
Some states it's legal for recreational use, and others it's just for medicinal uses. Do remember that marijuana use still remains a crime under federal law.
It's illegal under all federal laws.
It is illegal under all federal laws, and all schools are subject to the Drug-Free Schools Act, also a federal law. So you're going to have an issue with students with marijuana regardless, just because you have a federal law issue, and I'm sure that all schools are still have things in their code of conduct that says, right, so it might be legal in Colorado, but you're not going to be doing this in Colorado while you're in school, right? So think hard about how you want to handle the whole, self-medicating. Like I said, it's a hard decision sometimes for a team to deal with. I will say that for students with disabilities under Section 504, so now I'm going to flip this a little bit and talk about 504. If you are, or you have a student who is a recovering user of illegal drugs, note that I said recovering, not currently using, that student is going to be protected under Section 504. If they are currently using, they are not protected. So it's harder to say, well, I should be protected even under IDEA if I'm currently using an illegal substance. Sometimes the issue becomes we have a hard time figuring out, are they really truly actually using or not, right? So I caught you with the substance, but I didn't catch you under the influence, so are you really using it or not?
But in any case, I guess what I want to point out is that self-medicate, you can have a disability that you can show through impulsivity or through other well-documented behaviors, but proving a disability through proving a manifestation of a disability through self-medication is not a logical analysis. I mean, it might sound appealing for a student to make that claim, but it doesn't play out if you follow the logic. You're not going to. Self-medication is not a manifestation of a disability.
Right. It's not an impulsive act or something along those lines. Can I tell you my very favorite self-medication story, and then I think we're about done here. So my very favorite self-medication story happened years ago, where we caught a student who had ADHD and caught him with marijuana at his high school, and the family retained counsel because, of course, that's apparently what you do when your child is caught with marijuana at the high school and you don't want them to have a consequence. You retain a lawyer. And the lawyer called me and she said, Christina, I don't know why you would be thinking about expelling him. He was self-medicating. He has ADHD. And I said to her, we're going to delete the lawyer's name, right? And I said to her, other lawyer, can I just tell you that your client was caught with enough marijuana to medicate half of his high school, and it was all packaged for distribution. So I really don't think that we can say he was simply self-medicating when we had all these little baggies, like all individually done, right? So don't give me the self-medication excuse.
Self-medicating everybody.
He was. He was medicating a lot of people. My other really great story on just marijuana use in general, right, in school, is the kiddo who decided that he would lace the brownies that they were baking in home ec class with the marijuana. And he somehow thought that the teacher wasn't going to catch on to the fact that the entire home ec room started smelling like the marijuana that was in the brownies. That parent also claimed that it was impulsive and he just couldn't help himself, right? Let's just say that nobody was buying that in either of those situations.
Those are great stories. Thank you.
You're so welcome.
Yeah.
I love the drug offense stories. They're always so good.
They're always interesting. So anyway, thanks for joining us to talk about MDR. And next time we will continue with this theme of mistakes and talk about additional mistakes that school districts sometimes make and how to handle them, because mistakes are common and we're all human, we all make them. And how should you as an administrator react when somebody in the district, when a staff member has made a mistake? In the meantime, please rate us on iTunes and Stitcher. Please give us great ratings, and we'll be in touch. Thanks.
Thanks,
Bye.
everyone.